I own my own law firm. I'm on the East Coast of Florida. We did not have an internet outage yesterday on this coast, so we're doing good over here. And by request, today we're going to be talking a little bit about assignment of real estate contracts. I know this was kind of posted, and actually Brent from Omni Title went, hey, I have a group of realtors that basically are asking, questions about assignment of real estate contracts. Can you put together a little presentation and take what you know and kind of, provide the information to you guys. So here we are today. So assignment of real estate contracts. And if you guys have any questions and all that, what I'll do is if you'll wait to the end and just write down whatever questions you have, and then we'll kind of open it up and, I'll take any questions anybody has. Okay, so can a buyer assign or transfer rights to a third person before closing is typically the question that we get. And in Florida, the closing process normally begins with a written sales contract where a seller is committing to sell his or her home and a buyer commits to buy the property. Okay, what some buyers and sellers may not realize is that after the parties sign the contract, the parties can change. Under Florida law, buyers can legally transfer his or her rights in the pending sale to an independent third party. This means the deal may go through with a buyer who's different from the one who signed the contract. For many years, it's been generally accepted in Florida that land sale contracts can be assigned. Sometimes this is easily determined by which box is checked on the contract, or another way is after the buyer's name, it'll say purchaser and or assigns. Either one of these options places the seller on notice that you may be seeing a different face at the closing table when that comes. So let's start with when can't a sale contract be assigned to by the buyer, okay? And the key here is the sales contract is not personal to the buyer under the terms or by its nature, okay? There can be no assignment by the purchaser, okay? As explained by the Florida Supreme Court, real estate buyers will be allowed to assign their contract or sell the contract to someone whenever they choose to do so, unless there's language in the contract that prohibits it, if the assignment would violate public policy of the state of Florida, or if it would violate some kind of state or federal law or statute. One other possible limitation on assigning a real estate sales contract, okay, assuming that the contract is silent on the issue of it being assignable, it may not be assigned if the seller has agreed to sell to this particular buyer because of explicit reliance upon the buyer's personal credit to cover the transaction. So when a contract gets assigned, what are the duties? If the buyer enters into an assignment with a third party, the deal is to sell the property as described in the original sales contract. That doesn't change. The buyer is subject to a legally enforceable agreement when he or she signs the contract to buy that home or condo. If the buyer wants to transfer the contract to an assignee, the first contract does not change insofar as the rights and duties of the original parties, unless the seller agrees in writing to allow the buyer to be released from liability. We'll get to that in a few slides. The assignee needs to make sure that all the duties required by the buyer under the sales contract are performed in order to close the deal. The assignee takes the legal responsibility of tendering to the seller the purchase price at the time stated in the sales contract. He or she will need to perform as the buyer would have been required to perform under the agreement. So they're taking exactly whatever rights, the assignee is taking whatever rights that the buyer would normally have. If the assignee does not fulfill his duties, then the seller can argue the sale contract has been breached, thereby allowing the seller to retain the buyer's deposit and seek any other remedies set forth in the contract. As long as the seller is ready and willing and able to provide the deed to the original buyer, the seller would win this argument. So what are the assignee's rights? Once there's a legally binding assignment in place, the assignee has rights under the sales contract. However, the terms of the deal do not change just because the assignee is involved now. They get the exact same contract that the original buyer had. Assignee does not have any more rights than the buyer had at the get-go. The buyer cannot transfer something to the assignee that he or she doesn't have. Furthermore, the assignee will be subject to the rights of the seller in the original sales contract. If the seller expects something to be done by the buyer in the contract, then the seller can legally expect the assignee will perform the task as well. If the seller has defenses against the buyer under the sales contract, those defenses will be able to be asserted against the assignee as well. Bottom line, if the buyer and third party decide to enter into their own agreement where the buyer signs his interest in a pending sales contract to buy a home or condo in Florida to the third party, great. But the assignee will not stand in a more favorable legal position than the buyer just because he's a third party who's come into the deal under an assignment. So what are the seller's duties after a buyer's assignment? When a buyer assigns his or her right to a third party, what does the seller have to do? Well, the seller is usually not a party to the assignment unless the contract requires approval of the assignment. The assignment is an agreement usually between the buyer and a third party, so assigner, assignee. Accordingly, the seller has no responsibility to determine who the assignee is in order to close the deal. All the seller has to do is meet the terms of the sales agreement. It's up to the buyer and his or her assignee to work out the details of getting to the closing table at the time and date set forth in the sales contract. So the big question is, how do you sign a contract? In Florida, you get a choice. You can check the box that indicates that the buyer may assign and thereby be released from any further liability under the contract. Second option, you can check the box that indicates that the buyer may assign, but may not be released from liability under the contract. Or 3, you can check the box that says the buyer may not assign the contract. As a buyer or a wholesaler, you want to check the first box. As a seller, you want to check the second box. Okay? This gives the buyer enough flexibility to make sure the deal goes through if it hits a personal snag, but it doesn't let the original buyer off the hook. The conflict of interest here between buyer and seller that these options creates a negotiation opportunity in practice. If the counterparty wants to check the box most favorable to themselves, you might ask for something in exchange. That pretty much covers assignability. So I'm going to see if anybody has any questions.
Hi, David. I'm going to unmute myself. I don't know if you could hear me.
I just stood up here.
I've just been involved in a couple of assignee where the end buyer actually in some wholesale land transactions. They overall went pretty smooth with it, but yeah, it was strange, because you've got, say it was a small lot and there was a contract on it for $2,000 and then the wholesaler resells it to my buyer for $4,000. So
yeah, and they basically sell the rights to that contract, and you do have that out there, and that is prevalent.
Right. I mean, and their contract with the actual seller, it wasn't an MLS type, Florida realtors contract. It was, written by a lawyer, but that was about it. So, I mean, one question I would have for you is, if they have some sort of contract like that, and there was a time date if this was to close at a certain time, what would be the wholesaler's, responsibility if they don't get a buyer within that time period?
If they don't get, they're basically responsible for the original contract. So nothing changes in the original contract. So it's essentially, if you pass a date and they're not ready to close because they haven't found somebody to basically wholesale it out to, they're basically on the hook as it was a regular contract.
Okay.
So the same thing as a buyer blowing a deadline.
Okay.
So it's the same responsibility.
Okay. That makes sense.
Yeah.
Part of my question, Daniel, and I think this is most of it, we're all familiar with the part of our contract and the checking of the assignability and that kind of thing.
Sure.
But when it does get assigned, what kind of paperwork is required, needed? What rights do we have as the agents to ask for documentation that it's been assigned?
So essentially what it is usually it's just there as realtors, you guys just basically do an addendum, basically just swapping out the parties. And that's to kind of keep everything clean on your end. That's pretty much, it goes based on. So if you have an assignable contract and they are assigning, I always recommend just to kind of keep that paper trail of, okay, so we're assigning from the original buyer to now this buyer.
Right, but the seller doesn't need to agree to it. That's usually when we think of the word addendum, that's an agreement now between the buyer and the seller. And in this case, the seller wouldn't have to agree to it because he's already agreed to it in the contract, right? That's part A of my
Correct.
question.
Yeah.
Right,
Yeah.
so this.
But there's nothing, always to err on the side of actually documenting it, versus not. Technically, no, you don't have to do it. They can assign whoever shows up at the closing table at the end, it's assignable. It's basically from a seller standpoint, it's like closing with the original owner.
Okay.
So there's not much there in terms of requiring proof.
All right.
Most of the time what I see to kind of keep everything clean, they'll just kind of do an addendum. Just basically, we're swapping out this for that.
Okay, now we've seen some other, and that's the easy way to do it. We've seen some other ones where the assignee now takes that property and decides to start marketing it for sale.
Okay.
As if it's their own. They may hire a real estate company and sign an agreement. They may draft up something that looks like a sales contract with the new buyer. And that's, I think, where our holy heck of a mess comes in. Because the FAR contract doesn't automatically give them rights to market. So can you kind of touch on that whole portion of it? Okay, I'm under contract, I'm the buyer, and I've got assigned but not released from liability. I want to go out and find a new buyer. So I want to go out and market it. What do I have to do in order to legally, quote unquote, put it up for sale, put it on Facebook, put it on Instagram, put it on Craigslist, put it in the newspaper, put it in the MLS. That's our big hit.
Yeah, and that's probably going to create some red flags. Putting it on Facebook, putting it on there. I would say the biggest issue is actually putting it on the MLS because you're basically marketing something for sale. Okay, that's not, you don't own.
Right, and that's what we've actually had that happen here. It was the person had gone into a contract to purchase it, then went and hired another real estate company, put it in the MLS. Yay. And then when we found out that they had no rights legally, I guess, to sign a contract for sale and purchase to convey it. And after our buyers and sellers negotiated that out, then we found out all of a sudden that the person who signed the contract didn't own the property yet and wasn't disclosed on the contract anywhere. And now we've got, okay, does the real estate agent who's representing this quote unquote seller know, and that kind of thing.
That's actually the first time I'm hearing about that. I'm not surprised that actually happens. Okay, yeah, that's not,
Yeah.
you can't really list something for sale. Okay, because essentially when I'm selling, when I'm with assignment, when it comes to wholesalers, they're not actually selling the property to someone else down the road. What they're actually selling is the contract. Okay,
Right.
And MLS is not a place to sell the rights to a contract. That kind of goes against your guys' realtor rules. That's not the place for that. Most of the times when I'm seeing assignability, the investors already have the buyers on hand and they're just selling the contract. So going back to the previous question where there was property being purchased. So there's a contract. I'm selling that contract to the next person down the line. I'm not selling the property.
Right.
So I believe in your instance where somebody is basically trying to sell a property that they do not own. No, it's pretty much surmountable of fraud.
Yeah, that's what we thought. We brought that up to the company, and the next thing you know, it was terminated in the MLS, and another real estate company took it. But that was, yeah. Can they put something? I guess that would be my question. So if I were the buyer and I was going to go and look for another buyer, could I put something in the agreement that would say seller grants the buyer rights to put in MLS to publicly market the property? Is there something like that they can do? I'm wearing my buyer's hat.
And honestly, I don't have the answer to that question. Okay, really, who would really kind of know the answer would be the MLS. I don't think the MLS actually is going to allow that.
Well, we're not, see, attorneys write contracts. We don't.
That's the issue is, okay, you screw up, I'm the buyer, who do I sue? Well, I'm gonna sue the MLS because they have the most money. And that's why I'm here, is because that's what I'm worried about. Is we have a little bit of wording in our rules and regs that say yes, you do signability contract, but what does that even mean?
You have a signability, but
Yeah, because what,
basically, and this is kind of a tough issue. Really, the real problem is, and I actually posed this as a question to you as chairman of the MLS. Am I allowed to basically post something for sale on the MLS that I don't own?
I would say no, but if we don't have a signability contract really defined, other than you have to put confidential comments. I don't know.
yeah,
That has
that's,
to be discussed.
yeah, because normally the way we've been working with assignability is like the way you first talked about it at the beginning was we put it in there, maybe assign, like if we have to add mom or dad, for credit purposes, or, we've got a movie star who's asked us to go into a contract and then switch it over. That's been very typical for us and we're used to that. But now we're seeing because the prices are rising so hard that these people are trying to buy stuff to flip it. They'll go into a contract with Christopher Allen Homes on a new construction, and then they're out there trying to market it with the intention of assigning the original contract over and making a quick $10,000 or $15,000 spread on the deal. So what we're trying to do from our end as realtors is protect our potential buyer, our buyers from getting into this circle of who really owns the property. And then if someone comes to us and said, I've got a contract with Christopher Allen Homes and I want you to market it and help me make money on it, where's our process? But it sounds like we couldn't put it in MLS at all.
Yeah, I would say you're not, yeah, because you're not actually signing, you're not actually selling the final property because you
Right.
don't own the final property. You are, if you advertise it as, hey, I'm selling a contract for the purchase of this property, it's one thing. But if you're trying to sell a property that you do not own, that you have not closed prior, no, there would be some ethical concerns to that.
Right, yeah, and legal, that's what we're looking at, yeah, because you get a contract
definitely
with someone who
run into
signs it
ethical
and they don't own it, yeah. So
Yeah.
it's an assignability of contract.
I had two transactions. They were both actually in the MLS. They were put in by like flatfee.com. So
Okay.
it was kind of they said, do not contact us for the offers, contact this person directly. One of them specifically said in the notes that this was an assignability, assigning contract. But there were two in the MLS actually, and it looked like the one guy was, because I asked him, I said, well, we have a contract. Can you mark it pending? He's like, yeah. He goes, I'm going to get it removed. So that kind of was like, the termination thing. Once they kind of got it out there, they grabbed a buyer, terminate the listing. So
Well, that would be a violation of our rules, right?
yeah. Yeah.
I actually
Yeah.
kind of
Probably
encountered this a
seller
lot, and
as
I
well.
do believe that there were actually realtors that got in trouble for this. What was essentially happening is when the housing bubble burst back in early 2000s, what was essentially happening is you were having a lot of these properties come on the market that were super cheap, $10,000, $15,000, typically condos. And I know there was actually a string of realtors that actually got in trouble because what they were doing is they were finding buyers for these properties, submitting offers, putting as the seller, owner of record, and making it assignable. And what was actually happening was the realtors themselves were actually purchasing it prior to their client and then upmarking it, behind the scenes, upmarking it and then selling it to their client. And that kind of created a mess.
Well, and that's it, we don't want the 06, 07 debacle, happening again, because that's what you're saying, everybody's after the quick buck and
Right.
that kind of thing.
So that's kind of where I saw. Most of the times when I'm seeing assigned contracts, where they're assignable, typically it's somebody buying in the personal name to begin with, and then it transfers, they want to transfer it to an LLC.
That was my question, was we have a lot of
That's
people that have,
typically 9 out of 10 times when I see an assignable contract, this is eventually going to an LLC.
okay.
Situation with the dead person.
Yeah, now Jean had, yeah, we love to talk about dead people. We're very irreverent here, Dan. But Jean, and she's got the turquoise shirt on. How are you? Can you see?
Yeah, go ahead.
She's had layers of this with people who passed and trusts and
Yeah,
assignability.
it had to
So I'm
do-
gonna let her bring it up.
It had to do with probate. Took a cash offer on a lot where we had established that my seller was the personal representative of the estate.
Okay.
So the cash offer and had the little box checked, can be assigned,
But not be released from liability.
but not be released from liability. And coming to find out, after delay, he wanted to use his own title company. So I'm like, okay, fine. So his title company, first off, didn't pick up the file to see what the underwriter had wanted until 3 days before it was supposed to close. And of course, the underwriter wanted a couple of more probate items. So we gave them a week and a half for that and they still didn't have them. Come to find out that this was the title company. I don't know if they were working in collusion with the buyer that found another buyer on the other end. But I didn't know that it was even being assigned until 3 days before it actually closed. When they finally said to me, I said, I need the buyer's settlement statement because on MLS, I'm legally representing him. That's what he said. You can represent me. I don't care. I'm not a realtor. So that's how we got around that. And I'm just wondering, it just seemed to me that it took so long to get it closed.
So are there any?
He was looking for a buyer.
Probates are a difficult thing when it comes to probates.
Yeah,
Okay, they typically take a while. Okay, I've done a few of them. I've done my share of probates. It kind of really depends on, what the situation is, in terms of, where I got to file, because it's not always the county where the property is, and working at their speed of the court system.
I'm sorry, we'd already taken care of the primary residence property. This was the lot next door.
Okay,
So we had already gone through with no skips and jumps and hiccups through
right.
the primary property,
So
different title company.
So your concern really is the fact that we weren't notified of any assignability.
We were not
So that,
notified.
I guess that's the crux of the matter. If we have a contract that says assignable, would not release from liability, or assignable, but not, however.
And if something would have happened, you could go back. If it's not, you're not releasing, you go back to the original buyer, but they don't have to, there's no requirement for them to actually let you know.
I guess that was our question.
As long as they're gonna be able to close on that contract to the terms of it, that's,
So we may
that's,
know until we see the preliminary closing statement, and all of a sudden, there's another name on it. Now, that brings me to part B of the question. So now the seller, the seller sees that his property that he sold for $50,000, or he wrote a contract to sell for $50,000. Now he sees it's being assigned for $100,000. And the seller says, holy crap, I'm leaving money on the table. Now I don't want to sign. I don't want to sell. Now what?
they're under contract, they gotta sell. It's not,
So who sues the seller for specific performance? The assignee or the final buyer?
they would basically be the assignee. That would basically sue for the specific performance of it because he's the one now with that contract. It's the same as the buyer.
Question, when we see that little box check, if we do an addendum to the sales contract, saying that should the property be assigned, that we need notice when the contract is signed?
You mean just expand
Just expand it, just
from
expand.
beyond the simple checkbox. Yeah, now that, yeah. Are there any?
'Cause I'm not changing the contract. Not touching the contract.
So I guess so that's what we're looking for. You're looking for like
Yeah.
some kind of an addendum or legal wording that the buyer, that we could add into the contract that would say, in case of assignability.
Proper notification.
Oh, sorry, I'm talking the wrong way, but. So that's what I think they're looking for.
You can definitely put that if they, they'll give, buy the seller, X amount of days notice. You know, you can do that if they sign off on it, but there's nothing forcing them to sign off.
Okay.
Right.
Because
So-
they don't need seller's permission to do so.
Okay, so now we'll put you on the hot seat. What are you, so since we've been doing this assign but not be released from liability for years and years and years and years, do you think in this different marketplace that maybe we should consider recommending to our customers that they do the release, but that not be released from liability and then negotiate if they want to assign it?
Say that one more time, because the last
Okay.
part of that cut out.
Would you think that maybe it might be a good idea to discuss with our customers release, not having that assignability in the contract, and then having the buyer come up and try to negotiate an assignability?
Yeah, I mean, it's always, you know, yeah, it's always a negotiable point. Everything is negotiable, you know, with that, you know, as a seller, you know, you don't, if you're going to do assignment, you don't want to release the original buyer from the liability of it, you know, and that's the point that you're going to be pushing. And then as a buyer, they're going to want basically the buyer to be released from the original liability of it, you know, and that's where the negotiation point comes.
Right.
Is it proper to ask or request a commission on the increased on the end for the realtor? Okay, you've checked this box, you can assign contract in the addendum. An addendum must be notified, and 3% of the proceeds of the difference to go to the listing agent.
Again, if they agree on it, great, but their argument's going to be, they probably won't agree on that for the simple fact that that actual contract is between buyer and assignee and actually does not involve you, is going to be the problem.
Okay, that makes sense.
So you're not actually part of that contract.
Okay.
Right. The agent would have to have an agreement with that final buyer that
Yeah.
they're gonna get. Okay. Or
You can
the
do it, you can do it if they agree to it, but
Yeah.
again, you know, it's, why would they?
Yeah. Well, my question is why would a seller take an assigned contract in this time of what's going on in the market?
That's a rhetorical question.
I know, that is rhetorical. I'm sorry.
I think, hold on.
Two questions that were sent in ahead of time, and I know Brent is on the call now too, which we want to say thank you to Brent for putting this together for
Thank you,
us. But from a title standpoint, Dan, what happens at the closing table? So we've got the seller who has gone into contract with this buyer. The buyer has assigned a contract to another buyer. How does that pass through hands at the title at the table? So do they do like a full warranty deed and then turn around and do a quick claim? How does that process look paperwork wise with the deeds?
So from a title standpoint, essentially how that works out is it's a warranty deed, just like they were the original.
It's not, what she's asking is if there's going to be a flip, basically, two closings. Are they going to?
No. No, it's still only one clause. We basically proceed with that assignee as they were the original purchaser. So, and if you got, for buyer's agents, in regards to doing that, don't tell the title company a day beforehand, please.
Yeah, really.
I know you're online, Brent. I hope you're unmuted. So I think, because part of what you title companies do is investigate the people, right? The final buyer, you're doing name searches and things like that, correct? Unmute yourself, Brent. Unmute yourself, Brent. Oh,
Yes,
maybe there you go.
You mean the OFAC searches?
When you have a buyer for a property, you usually do a name search to make sure that for aliases and things like that. So,
Correct.
That's what Dan was saying. That's why you need to let the title company know more than 24 hours in advance so that they can do those searches. So that
Preferably.
Exactly right, please. Yeah.
what do you recommend so our agents have a timeline so that they can make sure that happens?
As soon as you guys find out.
And I think that's where our problem is sometimes if we're on the listing side, we're not going to know that if that changed until we see the preliminary closing statement from the title company and there's a different person's name on there.
Right, I would,
And a
72 hours.
Now, okay, and now my next question, I think this is where Jean and everybody was asking. So So the seller enters into a contract with buyer A for $50,000 with assignability. Buyer A goes find buyer B for $100,000. The final closing statement would reflect how much for the selling price. That's one of the questions our agents are going to ask for.
Is that for you, Daniel?
You can both answer it.
I can answer. No, it's going to reflect what's on the actual contract.
Okay, so the
Basically,
closing-
the assignment there, that sometimes you'll see it on a settlement statement. Sometimes you won't, but it's almost like a finder's fee.
Okay.
Sometimes
and
it's
the
done
buy-
outside of it. Sometimes it's done on it.
and
Yeah, that's how it
buyer-
was in my closings. Yeah, the recent closings, I had the same thing. It was whatever that gap difference was just an assignment fee payable to.
Correct.
So that's what I want to make sure everybody understood where the numbers were and where the money was going to be. That's,
So the actual
So-
purchase price on the contract does not increase because that would screw everything up. It's basically the contract as it was originally signed is the contract that's closing.
yeah, well, we've seen title companies try to change that around and really messes things up. Not you, Brent. So that's all right. So that's on, though it makes it really easy on super easy, just cash deals. What if one of the parties wanted to finance?
That's a really good one. I've never had one with I've never had one with a loan.
I mean, is it?
Loan would be a mess.
Yeah, I would imagine it would be.
When it comes with financing, it becomes a little tricky.
Yeah.
Okay.
I'm not sure.
And I guess it really come into play of how far down the line we are for that assignment. Okay. You know, they have a duty to close. So if they're basically, you're not going to see a lot of these. Okay, where they're doing it on assignments. Okay, because then there's an argument to be made that if you have a original buyer has approval, is going through it, you know, and has preliminary approval with the lender and is going through that process, okay, that basically now there's a reliance on that contract for your original buyer. Okay, if they're bringing in and assigning another buyer, okay, unless that buyer's coming in and paying cash, you know, you're not going to see it because it's going to screw up the deadlines.
Right, okay.
So I guess to answer your question is yes, hypothetically, yes, it could happen, but it's impractical. So you're probably not going to see that.
Okay, so
I
now,
as a past lender, I had a hard time finding an idea that a bank underwriter and their appraisal process would be able to clear that. And
Right.
just say,
Yeah. That's why I'm saying I've never seen one.
so,
You're not all over.
so when you're doing them, Brent, the title company needs something that shows Sam Jones is assigning the property to Sally Smith. What wording, if we're in the mix, stands and Brent, what kind of wording do we need to have on that assignment of contract?
I mean, just really, I've seen it just as an addendum, just laying out exactly who it's being assigned to. That's all I've seen. And then obviously have all the parties sign, agree to that, you know, basically it's a buyer name change.
And then I've also seen it being, you know, on the other side of being, you know, attorney wise, where there's actually a contract between, you know, and it's usually fairly simple between, you know, original buyer and assignee.
Do you think it's easier to do assignability than doing simultaneous closing kind of things?
That's
You know-
where, yeah, that's where we were talking about last week when I was doing the class on the 21st, like, and Daniel will be able to confirm with you, but we were talking about whether or not on the original transaction, you know, for me, from the way I see it, it would be a lot cleaner if we actually recorded that deed and then just recorded a new one afterwards to the assignee, to keep it clean. But Daniel, we don't have to do it that way though, right?
No, because the assignee is basically taking that contract as it's now his or hers. So
Yeah.
it basically is if going back in time and doing the assignee originally being the buyer to that. So doing the two simultaneous closings, it's not, you know,
Because-
it's not necessary.
Because no funds are being dispersed on the first one.
Right.
Doc
Yeah.
stamps, you have possible title insurance, capital gains issues, all of those other kind of issues on those simultaneous closings. So the assignability becomes much more advantageous to a customer who's looking to make a little bit of money without having to spend any money other than deposit. Because really that's what they're doing. Put a $5,000 or $10,000 deposit down and go try and find another buyer for that property.
Yeah, no, I've seen it way worse. I've seen, I was talking to Joanna about this, which I, like, from my perspective is an unethical way to do it, but I've seen them only put 300 or 500 down. And because they know at the end of the day, if they can't assign it, they're just like, oh, well, I lost $300 or I lost, you know, who cares? But it really puts the original person, the seller, it's just, I feel like it's unethical to do it that way, but they do, I've seen them, you know, do it with $500 EMDs because they don't care if they lose $500, it's nothing to them.
So for you guys as listing agents, that's like a red flag right there that you may have some
Right.
issues. And you might want to, if they're going to take that assignability with the release, then go for a heavier deposit to do that. And thank you for bringing that up, because that does, when you're looking at those contracts, I think those are some of the things we're looking for, right? You know, it would be EMD, maybe extended closing date kind of things. What other little flags or things would we look at in a contract that would alert us to be more
Mostly it's going to
concerned?
be the EMD. The big one's going to be the EMD. You know, do they have enough skin in the game that if they're not able to actually go through with it, you know, it's going to hurt. You know, that's going to be a lot of it. I deal with a lot of assignments because I actually represent a number of investors where they kind of already have their pool that they're selling. It's their clients. So they'll buy it under their main company name with the right to assign, knowing which client's going to pick it up. Now, ultimately, if they can't find a client that's going to pick it up, they'll buy it themselves. Okay, so they'll go in and they're buying properties, you know, all over the state, you know, typically around under 200,000, you know, usually
Right.
condos. And they're basically, they collect rental and all that. And they have a lot of clients that are each their own separate LLC, you know, and when they go to buy, they always have that as an option, knowing at the end of the day, they're always going to close on it, regardless whether it's, you know, their company or ABC LLC. You know, you know, those are the kind of investors, and that's why that's predominantly what I see when it comes to assignability. But they're willing to take, you know, they're willing to buy it themselves if they can't find, you know, another client to basically purchase.
Yeah,
Okay.
like, yeah, like the We Buy Houses cash, but like a lot of times with those ones that most likely those type is what we're talking about with EMDs of $300 or $500, because they'll get a FSBO where that person doesn't know the difference between an earnest money deposit and what's satisfactory to actually put down. If there's agents involved, they're going to be on a more alert because you guys are going to call them out and say, nah, we're not doing $300 as an earnest money deposit. You know, we need more.
And I don't know what your market is there on the West Coast, but here, if you put a $300 to $500 deposit down on almost anything, you're not getting a phone call back.
No, you get a nasty little text saying, hello, no.
Oh, no, it's not even worth their time. You won't not hear anything, and they won't, good luck, you just burnt that firm.
We try to be a little bit more professional and say, what are you, crazy? In a nice way. So is it easier to sue an LLC for specific performance or a PA or a trust or something as opposed to an individual?
It's easier to sell for specific
An
performance.
entity versus a person
To sue.
for specific
Litigate.
performance.
It's gonna be the same. It's gonna be the same. You know, it's gonna be the same.
Anybody else have any great questions, war
I
stories?
can tell you when it comes to specific performance, you know, it's, you know, one of those, it's kind of weighing the good and the bad on specific performance, you know, on what the property actually is. Yeah. You know, if it's you know, that $10,000 lot and sue for specific performance on it, you know, might not be worth the aggravation on that. And that's just from a practical sense. So, you know, I might be the only
Daniel.
friend that basically says don't sue.
Daniel, I've got a question from Jeff from the MLS.
Have you worked with any other MLSs across Florida that have been doing this, that are doing it correctly?
I can barely hear that one. One more
Are
time.
there any other MLSs like Palm Beaches or
Miami,
Miami or anyone you work with?
where they've had issues or they have got some policies in place to deal with this.
Not that I've heard. Not that I heard. Not, you know, I'm not a realtor. I don't, you know. I kind of don't know, you know, I know about the MLS and, you know, I have, you know, access through multiple friends to the MLS, you know, but on that, I can't actually speak to what they've actually been doing on that.
That's what we were wondering.
I can
Okay.
tell you that sometimes you go on the MLS and you see all kinds of crazy things.
Yes.
Yeah.
Yeah.
I go to Palm Beach County MLS and I can buy a mansion in Columbia for, you know, 300,000.
Oh, yeah. So I guess what you're trying to say to all of us, is we need to do our due diligence, and as soon as we get anything under contract, make sure it gets over to a title company right away so that they can check it, make sure that we have the right players. One of the other big issues we're facing over here, and I think you probably are on the East Coast as well, is more, and this isn't having to do with assignability now, but we have a lot of fraud going on with people pretending to be American citizens, or I'm in Canada, you know, and I'm really not in Canada, or I'm, you know, I'm from Iowa, but I'm in Ethiopia for real, you know, a lot of that kind of stuff going on.
Yes, we have that too here. I think over there on the West Coast, you guys got a lot more, you know, vacant land. And I think some of the land actually is a little cheaper than it is here in Palm Beach County. And anytime you kind of get that, you know, there's a lot of, there's a lot of fraud that goes on.
Yeah, I think every person you're looking at on the screen has had at least one this year.
Yeah.
And that's just 2022.
Typically, especially as title, and Brent can speak of this as well. You know, if you see vacant land, you know, foreign owner and all that, it's time to start asking a lot of questions.
Yeah. If you can't get your potential client to actually speak with you on the phone, that should throw up a huge red flag immediately. If you can't get them to call you, if they can't do that, then I would suggest the next question is, okay, if you can't call me, I need a picture of your driver's license, your passport, whatever else. You can send that in to me or Dan, and we'll be able to run an OFAC search or whatever to see if it makes sense. But
Yeah, they do. So that's the idea. Use the team, use the attorneys, use the title companies, bring all that in, and hopefully we won't have victims of that fraud, as we brought them all the way over there. But I think the worst has been the MLS, where these people have put it in the MLS, pretending, and they're basically pretending, they're purporting that they're the owners of the property that they only have a contract to purchase on. So
Something that actually goes, and I've actually been seeing this more and more, and I know Brent has too. Okay, kind of not so much about assignability, but especially here in Palm Beach County, we're getting a lot, everybody's basically competing with cash offers. It's coming to a point here in Palm Beach County that if you're FHA financing, you're trying to buy a place and trying to go through, your chances of actually buying a place on FHA financing here is becoming slim to none. It's becoming real difficult. So we're finding a lot of these fly-by-night companies that are coming in and going to end consumers and basically going, we're going to buy whatever property you want, and we're going to pay the cash, and we're going to put it down as a cash finance. Okay. And we're going to buy it cash, and then we're going to turn around and sell it to you on a simultaneous closing. And those have not been working out too well.
Or they turn them into buy here, pay here's.
Essentially, it's turning into buy here, pay here, but it's, you know, they're not real. They're doing so many of them, and it's like fly by night companies that are doing it. and they forget to do an HOA application or do this. So you got two simultaneous closings going on, and it's just becoming a mess.
I've actually had some of those.
And they're fly-by-night companies. Yeah.
And you don't know because you're getting proof of funds that the original buyer's cash.
Exactly. Yeah, but they're not, the companies that I've seen and I've heard of are not very organized, and those usually become a headache.
Well, how much profit should they take? I'm curious.
I have a hard time hearing us back here. so-
They're asking how much profit should
Are they looking for on the flip?
on the
They're usually the ones financing it on the back end to the end consumer.
Oh,
Okay.
good.
They'll do, or they'll turn it into a lease option kind of situation. Yeah, which is usually what you're gonna see. And that's probably gonna be more prevalent of that right now. Like I'm gonna use Christopher Allen because we've been doing it, but they could sign an agreement with Christopher Allen to build the house. When it's done cash, then they're gonna sell it to Susie and Sam for $50,000 more than they paid for it, but on a lease option for 2 years.
Right.
And Susie and Sally, they always get screwed in the end because they can't afford it. It's not gonna appraise out in the 2 years when they think they can buy it.
It becomes, whoever said it, it becomes like a buy here, pay here.
Well, we've got an attorney and we have a title company here. So if you guys have, we can turn this into the free for all Q&A. If you've got any questions at all regarding contracts, title, unmute yourself and open it up, because I know everybody's got at least one question. Dave?
Here's my question. It seems like people use the word wholesalers, and so many times it seems like they're doing licensed activity, but yet they're wholesalers, quote unquote. And it seems, I don't know, it just seems like everybody should be on the same playing field, I guess. Either you're licensed or you're not licensed. I mean, where's Florida come in on that?
Yeah, right.
Well, you mean how fast does DBPR go after those non-licensed people?
Yeah, I guess because I gotta believe there's a lot of people claiming that they can flip a house, do this, do that. But if their main income is real estate, they should be licensed. But yet they skirt underneath the law being a quote a wholesaler, and they don't need to be licensed. I see that in Michigan, and I don't know. Prevalent.
Yeah, and by law, they don't have to be if they're buying it for themselves.
Right.
It's when they start advertising out that they're
Right.
pretending, that they're
Are they
pretending. to
selling-
sell.
Are they selling real estate though, or are they selling a contract?
You're selling the
They're selling the
contract.
contract.
They're just selling a contract. They're not selling real estate.
Right.
Yeah.
Okay.
That's,
Yeah, but I
that,
understand. I mean, it's still unfair to licensed realtors. I'm fully in agreement with that.
but that's where the line is starting to get blurred. And I think that's where you guys
Yeah.
are, David, and that's when it starts appearing in MLS. That's when the realtors see it in MLS. So they assume that they are dealing with a licensed real estate agent on
Right.
that end.
Right.
And so on. And it could be when we have so many new realtors that are here that they don't know that the person who signed that listing agreement doesn't own the property. They're not asking for proof of ownership. They're not taking it over to the title company right away to say, hey, this guy who just signed this listing agreement, does he really own this property? Does he have the right to hire me? Does he have the legal right to pay me? Because now if he doesn't own the property, it's an MLS, we get it all put together in a contract, and all of a sudden doesn't close. Okay, the realtor's looking to get paid, and who are they going to get paid from?
Right.
The person who really owned the property never hired the real estate company. I think that's where the real mess is coming in. And that's where, like, Steve saw that coming in, where at least they had it in the confidential remarks somewhere that it was an assignability of contract. But like the other deal that we had in MLS where they put it in like they owned it. I mean, you read the contract, you read the listing agreement and everything else. It looked like that person owned it. And it wasn't. We pulled the tax bill and it had a different name on it. Yeah, and I'm telling her. So yeah, so the minimum is pull that tax roll up when you write the contract. I know I'm trying to keep looking at the screen to do that, but that's the thing, is just do your homework. Check it. And if you don't know, and if you think it's weird in the tax roll, call up your favorite title company, Brent, and say, hey, can you run a real quick title and find out who actually owns it?
Yeah.
Because they
that's-
might have flipped it within the last 60 days and LIPA hasn't caught up with it.
Possibly, that could happen, but yeah, just call me. I mean, I can do it. I can confirm the real owner in less than 5 minutes. I mean, it's very, very quick, and it's so worth that 5 minutes to save you guys the headache of working for free is 100% worth it, because if we think that we're dealing with a fraud or somebody, we'll red flag it immediately, and you can keep moving on to real people, real customers, real closings. But our underwriter, we can do searches on people and check their passports to see how often they've traveled and all that type of stuff to confirm they're a real person.
There you go. So it sounds like any kind of an issue really regarding MLS, we need to look to see if MLS has any rules about assignability of contracts being able to be placed in, or
Yes.
if they need to have some kind of rules or something like that. But we always end up going back to whatever wording is in the contract that the buyer and the seller agreed to. That's what's legally enforceable. Am I correct with that? Okay. And that's really that's just going to be what we have to do. I'll always check ownership, make sure your buyers are real buyers too. Don't be afraid to ask for their identification and check them out either.
Yep.
Because that's going on a lot, especially if they're going to sign it. They might not be who they say they are.
Exactly right. Yeah. Sorry about being late today. We didn't have internet for basically the entire day. So
we told him what happened to you. It was the same thing with us yesterday. We got the phone calls for the office transferred to me, and I'm standing out in my field chasing bunnies while I'm answering the phone yesterday.
Yeah.
Until I got settled up. But we real estate people never stop. We get in our
Yeah.
cars, we make phone calls, we do whatever we have to take.
Yeah. I mean, I thought that we have 17 closings this week. I thought it was going to be hard. I didn't know how hard it would be until yesterday with no internet. I will not complain. I will not complain today at all. That was rough. But thank you guys for joining. Daniel is a great guy. He protects me, and he's very easy to talk to, and very accessible. You're not going to get a receptionist that says he'll get back to you at the end of the week. That's not really how he operates, or how I operate, for those that know me personally. And he's just a really legit guy, and he's here to help the same way I'm here to help. We're here to help you guys on your closings and help you talk about how to get new listings, new clients, and to get more closings along with that. So I really appreciate JJ allowing us to jump in here for an hour today.
Cool, very good. And for those of you who are online, I'm going to put Jeff a little bit on the spot. Since we have the director of MLS, if you have any burning questions about MLS, you could unmute yourself and ask, and I could change out my hot seat with Jeff, or I could say the words out there. Does anybody have any questions about MLS? Suggestions for MLS?
Oh, can I make a suggestion?
Of course you can.
Sure.
So if you're a listing agent and the commissions are not what typically, and each one is different, but if it's a 6% total and it's not 3.3, let's say it's 3.525.
Yeah.
Let's remember title. I don't have access to the MLS. I can't look. I'm only an affiliate, so I can't look at it to actually see the property card like you guys have. But I think that it would be awesome to really get that transparent, immediately upon getting under contract, not only so that I can know, but so the buyer's agent who read it improperly on the MLS isn't upset with everybody when they see that they're only doing a 3.525.
The MLS does not do anything with that. Because it's a contract, we don't touch it. So because of price fixing and antitrust, we can't even tell you what the value is.
Correct.
So the MLS won't touch that with a 10-foot pole.
Right.
Oh, it doesn't have commission splits on there?
No, sir.
It just shows what the buyer's agent's gonna get, but it doesn't ever show what the listing agent And the MLS will never get involved because that's why Zillow is like, all these lawsuits are happening because, you know, the 3-3 was standard, but it was an unwritten standard that
Right.
everyone followed. And now people complain about it. It's like, there's nothing I can do because the MLS doesn't take a stance like commission. We can't. We would get sued.
Yeah, commission is
I-
only between the listing brokerage and the seller, has nothing to do with the other brokerage at all.
Yeah, so it sucks for you for, you know, for your point of view, and people reach out to us and, hey, like, they think it's variable rate commission because they got a different amount from the other agent, but it's like, I can't do anything about that.
No.
Right, what you would need from the title company would be like a commission worksheet or an information, you know, and some kind of an intake form from
Yeah.
the listing agent that's going to tell you how the commission is going to be split.
Yes.
Because the listing brokerage is the one who sets the fee that the seller pays. And then our listing contract forms an agreement with the seller on how that brokerage fee, that commission is going to be divided amongst a cooperating office. So that's always our source document for the legality.
Gotcha.
So just ask, so you just need that information put together in a form that you get, you know, and then obviously different companies charge extra fees and things like that. So that's where that intake form for you would help. Like we have a brokerage fee at Jones and Company Realty in addition to the commission. So
Yeah.
we would put that on the form as well, because that's not the only other weird stuff that would show up, and it would be like if in MLS, if there was an additional fee charged to the buyer or something like that, we would see that in confidential remarks in MLS. But you wouldn't, and you never interpret what's just in MLS because they can make all kinds of agreements and negotiations on commissions and all kinds of stuff. So you just need it at the very end, the intake kind of thing.
Yeah. I've had buyer's agents mad at me because the commission was a certain way that they didn't realize that,
That's when they need to talk to their broker.
yeah,
That is a great response. Brent, you tell them talk to their broker because they're only offered what the MLS says they're offered. We're offering a compensation and that's what they should get.
gotcha.
Your other little thing that you might run into from the title end is if the agents or the brokerages are giving part of their commission to a seller or to the buyer, then you just need documentation from the brokerage that says we're authorizing you to take X number of dollars out of our commission and give it to XYZ.
Yes.
Yeah, and that, well, usually a letter from the brokerage. And that's what I
Yeah.
always say.
Some sort of inducement.
Yeah, or even disclosing to buyer and seller that there's a broker fee, because I've had buyers call when I send out the final settlement statement or the buyer closing statement for their cash to close. This happened probably 10 times last year, and they call me saying, "What's this 350 to XYZ Realty?" I'm like, "Well, that's your buyer's agent broker fee. He never told me we had a broker fee. I'm not paying that." That's
Same answer, talk to your broker.
yeah, right. Yeah, true.
I just closed on the contract.
Yeah.
So there's no question about it.
Yeah, that's a good part about Jones and Company Realty, we put it on the contract, we have a buyer's disclosure, you've got buyer's agreement, yeah, because if you don't.
Oh, yeah. It's never Jones and Co. It's never you guys. It's other ones.
Very good. Well, we've covered a lot of different things and we're very grateful for your time, Daniel, and very grateful to you, Brent, for being so open and transparent with us about everything.
Mhm.
And it really
Thank
just
you,
comes down
guys.
to communication. Any questions? We find you and ask you any weird stuff. Go to your broker first, ask your questions, call the legal hotline, which is really
Yeah.
wonderful to use, etc.
I'll
Thank you,
put
Daniel.
I'll put Daniel's personal cell. That would be your legal hotline.
Everybody else has it.
Yeah, if you don't mind, Brent can send us your email and your phone and your cell phone. So that if they do have any questions, they can communicate with you. Or if we're doing a sale over the East Coast, we're a member of Miami and Heartland Association. So we're always over there doing business too. All right.
Thanks for
All
having me.
right. Well, everybody have a
Thank you, guys.
fantastic day. And as we always say, Johnson Company, peace out.
Bye.
Bye-bye.
Bye now.